So that's something that's happening with the learners. Campers, this might be my favorite case that's happening right now. It's illustrated by a woman holding up a stack of money, like as if she's holding cards, and the money is going up in flames. I found it on Unsplash by J.P. Valerie. This is a case used to illustrate a case where the state of California paid $66 million to purchase a website for their park system, which is why the people involved here, I'm calling them campers. The website was you could California is a big state, lots of state parks. You can register for campgrounds, etc. They paid the $66 million for the website. The contract for the website did have accessibility requirements, but when the website was delivered, they did not have a good procurement system. We'll be talking about procurement in a minute. And so they got delivered a website that was not accessible, and they put it up. And now there's a $66 million lawsuit because that is what the state paid for this website, $66 million. And there's a lawsuit filed by Tim Elder, who's a disability rights lawyer in the San Francisco Bay Area, to try to recoup that money for the state of California. And it's filed against the vendor who built a website. They tried to get the case thrown out of court. The judge said, no, the case can stay in court, and we're following that. So this is, talk about a cautionary tale, a very cautionary tale about having procurement systems in place where you don't just put a sentence in a contract and hope for the best. You need systems, you need testing, you need roadmaps, you need requirements after the fact to say, what's going to happen if it's not accessible. You need involvement of disabled people. So that's one type of lawsuit that's out of those 3,000. And when you hear that, there's 3,000 lawsuits, and it's all like the vast majority are from a very, very small number of lawyers who are handling things in a way that I don't consider ethical. But these other lawsuits that we're talking about here, these are very real cases for very real people who are experiencing very real exclusion and using civil rights laws to make sure that inclusion stops. So I think that's a put in your pocket thing. Okay, employees, applicants, and retirees. There's more and more cases filed by employees, applicants, and retirees. Here are some of the issues that are being looked at. Applicant portals, health benefit information. There's a case by a retiree who can't go online and get his information about his health benefits, online assessments, employment software, and a whole variety of different types of work, job training software, conference software. So these are, I did it like this instead of by the name of the case, which I'm going to actually write a post for my website about this, and I'll put the case names in there. But because it's not so much about who's getting sued today about these things. It's about, does your organization, does your school, does your company have a system for looking at all this technology and saying, oh, we want to have a diverse workforce. We cannot have a diverse workforce in 2020 unless all this type of technology is accessible to people with disability. One of the most recent things that happened in this space happened last week. There was a lawsuit filed against Epic Software in Massachusetts on behalf of an employee who couldn't use the software. And unfortunately, a judge in Massachusetts federal court just last week did throw that case out of court. It's only one judge. It's only one state. And it's the lower court. We don't know yet whether there will be an appeal of that. I have one little quote I wanted to read you. Let me see. Oh, the judge said, if the case was brought by the National Federation of the Blind, it said, if NFB's argument is taken to its logical conclusion, no company could sell any products to employers in Massachusetts that was not fully accessible to employee users with a range of disabilities. Well, yeah, kind of, yeah. That's what it's about. You shouldn't be selling a product. But in this particular case, the judge decided that that case can't go forward under Massachusetts law, not under the ADA. So we'll have to stay tuned with that and see what's happening. But, you know, I want to be an honest presenter. So if things happen that are not advancing accessibility, I want to share those with you too. Okay, so eaters. We're talking about the type of people bringing lawsuits. Domino's Pizza, that was my Massachusetts accent slipping in there. Domino's Pizza was the U.S. Supreme Court deciding not to hear the case that was filed against Domino's about their website and about their app. I have 2 articles on my website, lflegal.com, about the Domino's case. You can just search Domino's in the search box, and you can find those 2 articles, and I explain the significance of the case. You know, there's a lot of jokes online, oh, who wants to eat Domino's pizza anyways, or why didn't people just use a telephone? But the importance of this case is that the Supreme Court really didn't take it up, and so the case is back in California in the district court, where Domino's can raise whatever arguments it wants to raise. You know, people should be able to use the phone. I don't think phone is ever equivalent of a website, but the ADA gives Domino's a chance to argue that. So we're going to stay tuned and see what happens. Maybe Domino's will decide to settle. Maybe they'll continue to fight. We don't know. But it was very significant for the Supreme Court not to take the case and let the Ninth Circuit decision stand, which basically said these cases can move forward under the Americans with Disabilities Act by people alleging that websites and mobile apps don't work for blind people. Okay, shoppers. This is a picture of the Walmart checkout, and there is a lawsuit pending right now against Walmart for the fact that these checkouts are not accessible. And what happened in the case is 2 blind shoppers in Maryland went to shop, couldn't use these check stands, had to ask for help. Like we were talking about earlier, all accessibility is about privacy. They had to ask for help, and instead of helping them, the employee stole their money. So this is a lawsuit that's a civil rights lawsuit that really brings up the privacy aspect of accessibility. The company tried to get the case thrown out of court, and just in the last couple months, the judge this is also in Massachusetts, I think. No, Maryland. Sorry, this is in Maryland. And the judge didn't throw the case out of court, so it's proceeding. We're going to be following it. I'll do another, next time I do the update, which will be at CSUN, maybe we'll have more information, but there is no written order on this. The judge didn't give an order. It's a woman, she ruled from the bench. As they say, ruled from the bench, meaning in the courtroom. She said the case can stay in court. And just one thing from the transcript, which is available, without question, the judge said, the issue here of auxiliary aids and services, which is the fancy way of talking about effective communication under the ADA, without question, the issue here of auxiliary aids and services and whether or not it provides appropriate privacy and independence of plaintiffs. So it's an ADA accessible kiosk case, and it's about privacy and independence. And again, it's about kiosks. So when we talked at the top about what is digital, I think I might have even left the word kiosk off the list. Kiosk is another type of technology that has been the subject of legal action. I have an article on my website that keeps track of all the kiosk legal cases, and you can find it by searching kiosk at lflegal.com, and you can see the other type of kiosk cases that are happening. Okay, patients. 2 things to talk about that. Again, patients is another place where the privacy really intersects with the accessibility. There's a case pending against the University of North Carolina Health System for not providing medical information, billing statements, EOB, explanations of benefits in accessible format. This can be Braille, this can be digital online. Again, when we're thinking about digital accessibility, we also have to think about what sort of paper we're still providing, because many organizations still provide paper. And how can we provide it accessibly, which usually is digital, can also be Braille, large print, or other types of audio formats. There's also a picture of prescription, 2 prescription bottles here. I've been working instruction negotiation for many years with most of the national pharmacy retailers on making sure that these blank labels, which is basically how blind people get prescriptions with blank labels, unless there are accessible labels, of which there are systems, talking labels, Braille labels. So again, when we're thinking about digital, we have to think of all aspects of what our organizations are doing. Citizens. There's a lot of cases about voting. Oh my goodness, the debacle in Iowa. I just kept thinking, this is like what happens just with accessibility. Nobody tests it. Nobody sees if it's going to work on scale. So voting, there's lawsuits and settlements about voting system in New York, online voting, voting machines. There's also, where I have citizens, there's a lot of lawsuits happening primarily in Florida by people demanding captions on when they're streaming government agency meetings and hearings. And most of those cases are settling. There are some court decisions recognizing that if you're having a public meeting and you want people to be able to participate from their homes, you have to have captions. Perhaps you have to have audio description, depending on the nature of what's being presented. So the law is looking at that. I'm going to go back a second to that education slide. I talked about Harvard and MIT. There's 2 other resources I want to mention. They're not completely in the last 6 months, so they weren't on the slide, but there are settlements with Ohio. There's one in Ohio, and there's one in Montana who the settlements that set the gold standard for what you should look at in an educational, especially higher ed setting, in terms of making sure everything's accessible. And you can find links to those, as well as a ton of good higher education resources. University of Minnesota professor Laura Carlson keeps a wonderful page on her website, and I will make sure it gets sent out to all of you, where she keeps up with all the higher ed digital accessibility settlements and cases and lawsuits, government actions. So I want to just go back to that higher ed. Okay, who else? Consumers of all sorts. So here's a picture of Beyonce, and I put this in because there's a lot of lawsuits getting filed. The ones that get attention are ones like this. Beyonce got sued because her website wasn't accessible. These question marks stand for a lot of other people who are filing lawsuits, who are consumers. Maybe some of you saw on Twitter that I was agonizing over whether to talk about the lawsuit filed against Pornhub by a deaf consumer